And she talks to me. What do you decide on that one page?
I'm good. I'm gonna see what it's about before I was.
Okay, then my, okay,
See,
yes.
see,
If you want us
I'm
to-
gonna see what- I'm gonna see how much immediacy it has. Somebody filed for immediate action on it because of the whole visitation. So I'll check that. And if there's hearings, I'll send it to you.
Yeah, that's fine. If you need me to come get it, just call me and I'll bring it over. Thank you, guys.
It's on. Here, could we go ahead and do that case? Okay, Rotor, Rotor correction, are you on the, if you want to turn on Commonwealth versus Durwood, Salisbury?
Yes, he's here. The video's upside down. I'm not sure why.
It's just that kind of day sometimes.
Yeah.
Okay. Are you Durwood, Salisbury?
I am.
This is 20 CR 0060, 21 CR 0064, and 21 CR 0065. Are you handling this, DPA handling this Durwood, Salisbury?
Yes.
Okay, we got him on. Your attorney's going back to get on the connection there, sir.
Okay.
Mr. Stockton, do you have yours set up?
I was in the process. I was having trouble.
Okay.
Should be able to get on that.
Okay. They're getting on. We'll make sure your attorney gets hooked in with us here yourself.
Okay.
Okay, there's Mr. Sheffield. Yes, sir. We're waiting for Mr. Stockton to get hooked in here. There's Mr. I've called the case of Durwood's Salisbury 20 CR 0060, 21 CR 0064, and 21 CR 0065. Are you Durwood Salisbury?
I am.
Your year of birth, Mr. Salisbury?
What was that?
What's your year of birth?
Oh, 1979.
Last four digits, social security number 6680.
Yes, sir.
Mr. Sheffield, do you have a motion?
Yes, Judge. I originally filed this motion and it was heard on March the 3rd. At that time, we did not know the status of Mr. Salisbury's upcoming parole hearing. And the court took it under advisement because of that. And so now we know that he did get flocked and will not be eligible for at least, I think, another 8 to 12 months, if my memory serves correct. So I just renoticed that motion to again request the court for shock probation now that we know that his parole is not going to be granted in the near future.
Mr. Stockton?
Your Honor, I'm not for Mr. Salisbury receiving shock probation because Mr. Salisbury, when he was convicted on this 8-year sentence, had 3 cases. One case, he had 3 undercover buys of about 1 gram each of meth. Another case, he had 2 ounces of meth in his possession. In another case, he had 1 gram of meth, and part of that was fentanyl. He also had all the scales and bays, et cetera, and all the paraphernalia needed to sell drugs. So I'm all for giving people with an addiction a break, but the problem people have with addictions is somebody supplying the drugs. And I believe that's what Mr. Salisbury was doing. So I'm opposing probation on behalf of the Commonwealth.
Well, Judge, we don't dispute that he had trafficking charges, but the root of the issue for Gene is and has always been an addiction. That's what got him into that whole scene in the first place, and he's capable of doing very well. He's got a lot of potential. He has some tools already at his disposal based upon some previous training that he's had, but he's very capable of getting out. He knows.
Well, I appreciate that. Meth is bad enough. It's the scourge of our area, but I will not tolerate fentanyl. I cannot understand under any circumstance how anyone can be involved in subjecting someone else to having fentanyl, which will kill people on contact. So I'm going to deny the motion for shock probation and hope he turns things around up there. Okay. Thank you very much. Okay. These are out of custody. We'll go to, do we have Michael Nethery here? It's a Cumberland County case in person. Ms. Costello, are you on there?
Yes, sorry, Judge, I was trying to unmute. Mr. Stockton noticed that motion on Tuesday for me to appear via Zoom for it. I was unable to get Mr. Nethery on the phone to let him know about this motion in time for him to be there.
When is this trial set for?
The 27th. And so when we were in court last, I gave him the date for tomorrow for the settlement conferences, just in case, but I was unable to get a hold of him.
Will he be there for the settlement conferences?
I'm hopeful tomorrow. Yes. I asked him to be there.
What do you mean you're hopeful?
Well, I asked him to be there. I expect him to
Under an order. He's under an order to be there, right?
No, Your Honor, he was not given that. I just asked him to come.
Yeah, we'd already had a settlement conference on him and we couldn't agree on anything. So we set the trial date.
Yes, but I asked him to come just in case.
Okay, well, I'm going to give you 24 hours to file any objections to the video deposition. And if you don't, I'll sign a submitted order authorizing the video deposition of the expert witness. Okay.
Your Honor, so you want me to file? I was going to give my objections on the record, but I'm fine to file a written motion. I can do that today.
Okay, let's talk about your objections. And then here, do you have any case authority that says it violates the confrontation if you have your client with you, the person's on live, and you have a right to cross-examine, they're fully visible to you on screen? Is there any case law on that?
Your Honor, Blankenship versus Commonwealth is a Court of Appeals case from 2019. And it talks about the situations in which, the limited exceptions in which a video deposition should be used at trial, at a criminal trial.
The other
And-
day that we had one that was just a chain of custody testimony, and you objected and have included that in your motion for a new trial. I mean, I would take these objections more seriously if they were more, directed towards some real confrontation that the person had. I mean, what is this witness going to testify against about Mr. Stockton?
It'd just be the lab examiner, and they can't be there that day. They have a conflict. They would be testifying as to the content of what they sampled. It'd be that there was so many grams of methamphetamine that was recovered.
Now, how would your client be prejudiced by, you have a full right to cross-examine and see the person, the jury can see the person, they're demanding. How would they be prejudiced?
Well, Your Honor, this isn't a motion for a Zoom call. This is a motion for a video deposition that would just be played at trial. It's not live for.
I said, how would your client be put at a disadvantage, because you have a right to cross-examine, object, have rulings. They have a right to look at the person and see his full deposition. How would your client be disadvantaged or constitutional rights be impinged upon?
Your Honor, when a jury is expected to pay attention to a video, it's very different than paying attention to a live person, especially a lab person with all the technical aspects. This is not just chain of custody. This is the
Where do you get your information? Do you have a study from Columbia Medical School or something? I would think that people watch videos more closely than they do when you have somebody in person. There's no obstruction of view or anything. Do you have any learned treatise that says that people are not as focused upon the testimony that they see, or are you just surmising that from your vast experience?
While I do have quite a bit of experience, Your Honor, the Supreme Court has also recently taken that into consideration under it when it was examining the appropriateness of Zoom testimony. And I can find that case for you. I just had it on my computer and I apologize. And how it affects the jurors' abilities to pay attention.
That was at the state Supreme Court. Did they rule on that?
State Supreme Court, Your Honor.
What did they rule? They ruled we couldn't do it?
Your Honor, they indicated, and I'm pulling it up now, and I'm sorry, Your Honor, my technology is not in my favor today.
I've got a docket to do here.
Yes, I'm sorry, Your Honor. It's everything just and Maryland versus Craig talked about the confrontation clause, and the court cited that.
What court are you talking about? We were talking about the Kentucky State Supreme Court. I don't think they had Maryland versus Craig.
No, they did use that. And I apologize, Your Honor. It was not the Supreme Court of Kentucky. They cited that case when discussing that. It was I misquoted, Your Honor, and I apologize.
Okay, well, I'm going to sign an order allowing the video deposition of an expert witness, and you can object at trial. You've objected now. You've stated the ground record. You can object.
And just
Thank
for
you.
further, Your Honor, I think 804 also would require them to say that the availability of the witness is for more of a reason of just not convenience. That, are they sick? Are they infirm? Are they out of the state? Are they out of the country? And in this case, they're just not available that day. I don't think it meets the burdens of a 804 and the rules that the rule of criminal procedure 7.1 and 7.2 allow for. 7.10 and 20 allow for.
Stockton, what do you have to say for the record?
I'll just have to get the information and file an affidavit or something. I knew it one time, but I've had so much going on, I can't remember, just to be honest with the
Well,
court.
you know, you've got these expert witnesses and that are under siege. You have to wait months and months and months and months to get them to make an appearance or anything. And you just got to take them. Is your client out of custody?
Yes, Your Honor.
If he was in custody, I don't think you would feel as strongly about it as you do now, because he'd be wanting a trial. Commonwealth has a right to speedy trial also. I just don't see how his rights are infringed upon at all. He's going to be present when the deposition is taken. You can consult him without any questions, and you can ask questions of this. And if the Court of Appeals and Supreme Court think I'm wrong, then we can try the case again. Okay, thank you very much. Okay, let's go to Tony Albertson. Tony Albertson. Tony Albertson here. Commonwealth know anything about Tony Albertson?
No, Your Honor, he was supposed to get evaluated at ACPC. I've not seen an evaluation. Supposed to be an outpatient, and he's not here in court, so I asked for it.
Judge, I've been in communication with KCPC, that they're talking about doing it telephonically now. But I don't have a date.
Well, where is he is a question.
I'm not sure.
Okay, well, issue a FTA. Brandy Beatty. Commonwealth versus Brandy Beatty. 21 CR 0018. Are you Brandy Beatty? We're here on review. What do you have? What does the Commonwealth have?
Your Honor, part of her review
Mr.
was-
Stockton, will you come around? Y'all stand to the left here. Stand to your left so Mr. Stockton can have some room. Okay.
when she was released on the shop, part of her shop was to stay on an ankle monitor, I think, for about 60 days. See how she did. I've got nothing but good reports on her, so I don't mind. Come out with this probation of something like that.
Or we're concerned she's in compliance.
Okay, sign, send me the order. Hey, continue to do well, you know, okay. Eddie Bowman,
There is that I think they can add on.
there's what?
There's a Troy Albertson on.
Well, we'll come back to it.
Come back.
Are you Eddie Bowman?
We have a pending case here on it. It'd be the same trial date.
19 CR 0041. Who is your client?
Bobby Lee Colburn.
Bobby Lee Calderon, 19 CR 0040. Are you Eddie Bowman? Born in 1999. Last four digits, social security number 8022. You're Bobby Lee Calderon, born in 1995. Last four digits, social security number 6133. What do we got here? What are the last four digits? Do what? I can't understand you. 8823. Okay, there it is. Yeah.
Two matters, Your Honor, I call a motion for trial date.
Y'all want to move all the way over here to the left? Go ahead.
File a motion to have the cabinet produce certain records, because when this case was continued the last time, the defense counsel wanted various records from various healthcare providers. We've gotten all of those, including from University of Cincinnati Hospital, but I've had difficulty getting records from the treating physician at this point in time. So I'd ask for an order. The cabinet has legal custody of the child. They need to provide those. That's my situation. They should be able to do it relatively quickly.
We'll draft an order.
And then the other matters, get a trial date. Not ask to be a few months off, because I've got experts, different doctor, Dr. Sugar, as well. So I'd ask for a little bit of time.
How about September 19th? Okay. How about September 6th?
Look at these 2 days. 2 days.
Okay,
September the 6th, 2 days.
correct, 6 and 7.
Thank you, Your Honor. I believe that's all I had.
Have a great day.
Same here.
Okay, have a great day. Troy Albertson. Troy Albertson. Combo versus Troy Albertson, 22 CR 0019. Are you Troy Albertson?
I am.
Born in 1969.
Yep.
Last 4 digits, social security number 4479. We have a,
4473. I know it is 4479.
okay. Pre-trial conference.
Judge, there's a restitution at issue here, and if we pay it, it'll go a long way toward resolving the case.
Mr. Stockton,
So I would ask the court to set us for our settlement and another pre-trial, and we'll know that number we paid for, whether we want to do it.
I'll go along with that, Your Honor.
okay, when do you want to set it for? When do you want?
July 7th at 1 o'clock. July 7th, 1 o'clock.
July 7th,
1 o'clock.
1 o'clock. And if you can't, if you don't get something resolved, then come back here. The next court date is on July 14th.
Okay.
Seven's at 1, 14th at 9.
Yeah, be here both dates. Okay,
Thank you. Your
okay,
Honor.
thank you very much. Ivy Branham. Commonwealth versus Ivy Branham, 22 CR 0009. Are you Ivy Branham?
Yes, Your Honor.
Born in 1998.
Yes, Your Honor.
What are the last 4 digits social security number?
0736.
Okay, we're here on a motion to consolidate and a motion to set trial. Move over to your left there.
Your Honor, since that time, the co-defendant is supposed to enter a plea today. He's in custody in jail. He didn't show up in court last time.
Yeah,
So I would like to pass Ms. Brown 1 month to see if he enters his plea.
I have verification.
okay, you be back here on July the 14th, okay?
Yes, Your Honor.
Okay, thank you. David Brown. Commonwealth versus David Brown, 22 CR 0016. Are you David Brown?
Yes, Your Honor.
Born in 1972?
Yeah.
Yeah, last four digits of your social security number, 35. Okay. What do we have here, Mr. Stockton?
Well, we weren't able to discuss this case because Mr. Brown didn't appear on the subject. Thank
Your Honor, I think this got mixed up on the dates.
You want to sit in for another conference, Mr. Stockton?
I will. Mr. Brown, if it was out one time.
Okay, you'll be here at 1 o'clock on July 7th, and the next court date's on July 14th. For Arden? Got a warrant. Is it bench warrant I put out on this? Wait just a second.
Yeah.
What do you have to say about that, Mr. Stockton, about the bench warrant?
Yes, that issue because it failed to. So,
Yes.
We didn't come to court today, so I'm wondering if you'll.
Okay, don't do that again. Don't do that again, okay? Okay. Laura Lynn Burchett. Commonwealth against versus Laura Lynn Burchett, 22 CR 0002. You're here today for the purpose of sentencing. You understand that? Have you, you born in 1979? Or the last four digits of your social security number? Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole? Is it substantially correct? On a plea, is there any reason this lady should not be sentenced?
No, Your Honor.
On a plea of guilty to trafficking controlled substance, first degree class C felony, you shall receive 5 years probated for 5 years. As of the entry of this plea, the defendant served 82 days in jail and shall receive credit. What's the court cost us? One what?
155.
155. You need some time to pay that? You pay it, I'll let you pay it $30 a month, first payment in 30 days. Okay, that should make it a little easier on you. And you'll need to meet with probation parole officers over here to give them full information. And do you have employment yet, ma'am? Do you have employment? Are you?
Yes.
Okay. Well, you go ahead and meet with them and they'll tell you when you have to meet with them, okay? Charlton Connor. Charlton Connor.
No, that's our notice. We can't see court. Go ahead and say no.
I'll go ahead and sign that. There'll be no opposition expressed. Edward Daly. Commonwealth versus Edward Daly. 22 CR 0013. Are you Edward Daly?
Yes, Your Honor.
Born in 1951. Born in 1951.
Yes.
Last four digits, social security number 2842. But Mr. Stockton, it says it's on for review. What do you have?
He's supposed to be or make arrangements for an outpatient evaluation. In case he thinks it's fine. I thought we talked about the Lord. I guess I don't know why. He put that on the document.
The board has been submitted for that, and it's waiting for response from SCPC
You want to put him on for next month,
next month.
July 14th? Let's just keep checking every month so we keep an eye on what's going on. Come back on July 14th, okay? Thank you. Cynthia Downing. Cynthia Downing.
That's the motion to revoke probation, Your Honor, and she's responding, so I don't think we want it.
You issue a warrant. Austin Edwards. Austin Edwards. Commonwealth versus Austin Edwards, 22 CR 0021. Are you Austin Edwards?
Yes, sir.
Born in 1999. Last four digits, social security number 5883. We're here on a pretrial conference. What does the Commonwealth have to say? Mr. Stockton, come up where I can see. Y'all move to the left here.
I received a motion, Mr. Cross, now, talk history about this case, and I think you thought he'd already filed a motion for his filed history, so. I think I have anything on that. Yes, Cross.
Don't think it's gonna be a lengthy hearing. We're just taking a look.
What is the issue?
Search your honor to 911 call. Basically, they call management and sheriff's department, what the status. So I don't get any question.
That's the issue. We're not taking it from, got all still in the house, but that's certain. Yes. So, yeah, it's a question.
Whose house was it?
He and his mother out there.
His mother's house. He was living there.
Yeah, possession of that.
Well, that's an issue, isn't it?
Very well, could be. That's the fact of the labor, Mr. Cross, I've got to talk to the officer, because I just got it.
When do you want, if it won't take on, when do you want to schedule it for?
If you want to do it, the rule labor meeting, or
Yeah, let's just do it the rule day, the end of the docket on July 14th.
in the afternoon, and then,
Well, or in the morning at the end of the docket, just at the end of the criminal docket. That's what we usually have.
So you're 10 o'clock.
Pamela Guffey. Commonwealth versus Pamela Guffey. 21 CR 00119. Are you Pamela Guffey?
Yes.
Born in 1977?
Yes.
What are the last four digits of your social security number?
6476.
54
6476.
6476? Okay. Here for a pretrial conference. What do you have?
Your Honor, we have a felony plea of course.
Okay. A motion has been tendered, ma'am, that says you wish to enter a guilty plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given? Let her get behind the microphone.
Yes.
Are you the same person named in indictment number 13?
Yes.
No. What's the indictment number?
21 CR 119.
Okay, superimpose. 21 CR 119, is that correct?
Yes.
Is your judgment impaired today in any way?
No.
Have you discussed these charges with your attorney? And are you satisfied with his advice?
Yes.
Have you reviewed the evidence that Commonwealth has against you and believe you're fully informed about your case?
Yes.
Okay, do you understand that you do not have to plead guilty today? You have certain rights under the Kentucky and the United States Constitution before I can accept a plea. I need to know that you understand those rights. I'm going to go down through the rights. At the end of them, I'm going to ask you if you understand them. You have the right not to testify against yourself. No one can make you say anything. Right to speak trial by jury, the right to be represented by counsel at your jury trial. You have the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, the right to apply the Commonwealth, prove beyond a reasonable doubt that you're guilty of the charges against you. You understand that by entering a guilty plea today, you give up all those rights. Do you understand that? Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided below. I do not attempt to accept the recommendation. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. And what is the Commonwealth's recommendation? I'll move to the left over here, Mr. Stockton.
This deputy's charged with 2 counts of traffic and controlled substance, first degree C felonies. The Commonwealth's willing to let her plead to the amended charge of traffic and controlled substance, first degree, first offense, 2 counts. She'll get 5 years on each count and run concurrently for a total of 5 years to serve. Commonwealth imposes probation and shock probation. She'll receive credit for time served, a court cost discretion of the court, and all evidence in this case will be destroyed.
Is that what you agreed to?
Yes.
Prior to accepting any recommendation, I will await the pre-sentence investigation report to be done by probation and parole. If I do not go along with it, decide to impose a harsher sentence, if that's not agreeable to you, you have a right to withdraw your plea and have a jury trial. Do you understand that? Has anyone, including your attorney, threatened, coerced you, or offered you anything else to enter this plea? You plead guilty of your own free will because you are guilty and for no other reason. Knowing your constitutional rights have explained, it's still your desire to give up those rights, but in a guilty plea and let the court fix your punishment under law. Now, do you understand that by entering this plea, any future convictions of felonies would be enhanced as far as a penalty range? Okay, is that your signature on the docket there? We'll accept the plea order, pre-sentence investigation report to be done by probation and parole. You'll be back here on July 14th for sentencing. Okay, thank you very much. Yeah. Shirley Guffey,
That's our motion to destroy the evidence.
being no opposition stated, I'll grant that motion. Haley Harbor,
My understanding is she's in custody. Clinton County Jail. I may be wrong. Well, Mr. Krause.
when we get the jail on. When we come to that docket, the Wayne County docket, remind me of that, okay? Patricia Jones,
That's another notice of the defense.
okay, no opposition have been expressed or filed, I'll sign that. Richard Mason. Cromwell versus Richard Mason. Are you Richard Mason? Okay, you're here, are you born in 1983? Last 4 digits, social security number 5063. You're here for probation revocation and pretrial conference. What's it come? What do you have to say?
Probation revocation based on a new indictment that was presented by an individual rather than a police officer. And I've got some new evidence that's maybe some of that evidence was approached. And I need some time in order to investigate this matter.
Okay, you want to continue it out a couple of months?
If there's no objection from the defense.
Anytime you get to leave free, man, there's no objection, right? So, okay, let's continue this to August the 11th. August the 11th. You want him in for a conference that month?
No, I think I can handle this, Mr. Shepherd.
Okay, August the 11th. Nita Neal.
Mr. Krause's case.
Do what?
That's Mr. Krause's case.
Patty Poor. Cromwell versus Patty Poor. Are you Patty Poor?
Yes, I am.
Were you born in 1973?
Yes, I was.
And last 4 digits, social security number, what?
3805.
Okay, you're here today for sentencing. Do you understand that? Have you had opportunity to look at the pre-sentence investigation report done by probation and parole? Is it substantially correct?
Yes,
Is there any reason why this lady should not be sentenced today? On a plea of guilty to trafficking and controlled substance, first degree, class C felony, 2 counts. You shall receive a sentence of 5 years on each for it to run concurrently for a total of 5 years. Serve 120 days on home incarceration with a balance probably for 5 years supervised. You shall be on, have you been on home incarceration?
Yes, I am.
Okay, and how many days have you got in on that?
I started on the 3rd of this month.
Okay, so you go ahead and serve that time out and your attorney will contact us when the 120 days expire. Okay, what are the court costs in this case? $155 court costs. I'll let you pay that at $30 a month. It'll make it easier on you, okay? Okay, you pay your first payment 30 days from day and 30 days after that till you get it paid, okay? Okay, you need to meet with probation and parole. Thank you very much. Kalira Whitehead. That was up for review. What is that, Mr.
That
Stockton?
just needs to be dismissed. My understanding is that the restitution for the COVID, the COVID played that full. We'll get it.
Okay, the only thing we got left is,
Judge, Matthew Thrasher is not actually on the Wayne County portion of the schedule. Was released this morning, he made it to court.
good, okay, Matthew Thrasher. Commonwealth versus Matthew Thrasher, 22 CR 0032. Are you Matthew Thrasher?
Yes, Your Honor.
Okay, you born in 1988,
Yes, Your Honor.
last four digits, your social security number 2239. Mr. Stockton, you come forward and tell us what you have on this.
Well, he has been a state inmate. He's got released today, I think.
Yeah,
And I will just ask just to sit for the civil day in July 7th.
okay, you be here on July 7th at 1 o'clock for negotiation and back here in court on July 14th, okay? So. Okay, that finishes the live docket except for Haley Harbor, which Mr. Cross represents. You know, Nita Neal has the DPA down.
Mr. Cross took over.
Okay, hold on. Okay. Okay, well, let's go off the record until it's 10 o'clock and then we'll go to the jail dockets.
On that.
Yep. Wait for everybody to get in here.
Yeah. That guy I used to work with, we had a federal court case. So he stopped out and took a shot. That's about this case. That's what.
Page 27, that is report copy.
State court and national bankruptcy court, customs acts. One difference 30 years makes the track. That's outrageous. I used to go down there a lot. I used to know that. Doesn't affect that.
See if we can get Melissa back over here. I don't know where she is. She left her purse, so she's not going to do it.
If the phone's limit, I should be right back.
He hadn't taken that sleep medication that he gets from,
My missed his eyes at home. I didn't know they were doing that. I was telling David. One of my good friends, she's working at the airport. She's got a gig shop here. She's her husband. She's working in the country. They have some kind of retinal eye scan at the airport.
well, you know, Governor Huckabee is selling this sleep aid stuff, and Larry Gatlin tell us changed his life.
Yeah, I saw that. That's all they do.
You get some, all you gotta do is take fruit and vegetable pills and sleeping pills. Your life will turn around. You'll be doing a 100-yard dash. Okay, let's go back on the record here. Commonwealth versus Nita Neal. (21 CR 00129). Are you Nita Neal?
Yes, sir.
Born in 1973.
Yes, sir.
Last four digits, social security number 8417.
Yes, sir.
What do we hear today, Mr. Stockton?
Well, Mr. Kraus got in this case, took over for DPA, and we didn't have time, so we can sit down and go over it. I think. You can't resolve it to the trial.
July the 7th. In July, will be the conference day, 1 o'clock, and you'll be back there on that day and on July 14th in court next time, okay? Haley Harbor. Haley-
First reading, Your Honor, I suppose. the main-
Okay, that's all of the live docket, correct?
Yes.
Okay, we'll call Haley Harbor when we go. Let's go. It looks like we've got Russell County on the line. Russell County, Commonwealth versus Timothy Brown, 22 CR 0026. Are you Timothy Brown? You have to unmute your microphone there. Commonwealth versus Timothy Brown. Are you Timothy Brown?
Yes, Your Honor.
Born in 1988. Born in 1988.
Yes, sir.
Last four digits of your social security number, 220026. It says we're here on a pretrial conference. Mr. Stockton, what do you have?
Your Honor, this is a fleeing and evading case. Based on what happened yesterday with the jury, if Mr. Brown would accept counsel, I would negotiate something with him where it would run concurrently and not add anything to his time, just to facilitate things. If he doesn't want to do that, I guess we can get another trial date.
Yeah, let's get another trial date. I'll just represent myself.
What did you say, Mr. Brown?
I'll represent myself.
Okay. Okay, let's set another trial date here. What did I say? July
You have to bring him over.
what? Will that July 6th date go, Mr. Stockton?
What case is set that day? I don't have it down.
Harold and Johnson.
Harold Johnson. I don't know, to be honest. I was hoping to be able to talk to her today but Mr. Hurd had a DUI trial, and so we could, and I'm shorthanded on help, so I wasn't able to interview her. That's the problem I've got. So I don't know if it'll go or not.
What kind of case is that?
And I just don't know about trying Mr. Brown again this quick. We just had one trial, and I know we've got a different jury, but I just don't think, and I'm not trying to insult Mr. Brown, I just don't think he's.
Wait just a second. I think you bring up a very good point.
Yeah.
Wouldn't it be fair to take him in front of the same jury?
I'm very capable. I mean,
Well, no.
I'm just
not talking
intelligent.
about I'm not talking about your capabilities, Mr. Brown. My point was, is we got the same jury again, and they might be prejudiced against you because of hearing that other stuff, okay? And the new jury was just sworn in today, so they'll be available next month. So I'm not talking about your capability. I'm talking about whether or not to be fair to you with a new jury, okay? When does the new jury take over? July 6th. So that'd be sometime in July. So July 6th will be the new jury, Mr. Stockton.
It will. It
Okay.
will.
Let's,
This is my problem. Mr. Brown's a state prisoner, and I'm shorthanded. I can only devote so many resources to so many cases. I'm not in a hurry to try him right now. I mean, he's got a 3-year sentence. If he wants to trial, I'll give him one in September, August, or October. But there's other cases that need to be tried before him. He
okay,
just
well,
can't monopolize the docket.
let's set this for another pre-trial on October 13th. Okay. October 13th is your next court date, sir. Okay, the next case is
Are y'all done with me?
yes, sir. Rebecca Major.
Give me just a second, Your Honor. I couldn't have her up here with him. She'll be right up.
Is Luther Luckett Correctional Complex online?
What was that, Your Honor?
Luther Luckett. Luther Luckett Correctional Complex, are you online?
Yes, Your Honor. This is CTO page. I'm here
I'll
with
go
MA
ahead and
Daniel.
make your case here. Thank you very much. Commonwealth Kentucky versus Daniel Moreland, 08CR0079 and 08CR77. Are you Daniel Moreland?
Yes, sir. Yes, Your Honor.
Born in 1987.
Yes, yes, sir.
Last 4 digits of social security number 9809.
9027.
9027. Okay, we'll make note of that. Okay, Mr. Stockton, what do you have here?
This is a case where Mr. Moreland's sentence was overturned in the Court of Appeals. The last time I spoke with Stephanie McMahon, I think's her name, at the Attorney General's office, which was last week, she says the Court of Appeals has denied their petition to rehear the case, and they're filing a petition for discretionary review. And I know Mr. Shefford has a bond motion.
Remind me of the case.
It's a sex abuse case. It had he had like a 10-year sentence, and some of it was alternative sentence. And they say, and the Court of Appeals is basically saying his sentence is expired at this time. No further. There's no other recourse for the Commonwealth as far as imposing additional
Was
sentence.
this a plea that he entered and then was revoked on?
That's correct.
Okay. What do
And
you
Judge, we refrained from filing for an appeals bond until after the Court of Appeals issued a decision in our favor. So we didn't, it's not as if we filed an appeal and then immediately asked for a bond. We waited for the decision, and, we don't know what's going to happen with the discretionary review, but.
Where will Mr. Moreland be if he were to get out on a bond?
Well, that's the thing that we've been working on. The Commonwealth had said they might be able to, they would agree if we could find a placement for him. And we haven't been able to secure a placement, at this
But when
time.
you get a placement that will follow the law,
that would,
I'll let him out on the ankle bracelet until the Supreme Court acts on it, if y'all will submit me an agreed order.
Okay.
Okay? Okay, thank you very much. Luther Luckett, I thank y'all for your cooperation.
Thank you, Your Honor.
Yeah. Let's go back to Russell County. Rebecca Major. Rebecca Major.
Yes.
This is 21 CR 0033, Commonwealth Kentucky versus Rebecca Major. We're here on probation revocation. Is that right, Mr. Stockton?
That's correct.
Mr. Sheffield, your attorney is here. Do you see him, Miss Major? What do you have, Mr. Stockton?
The violations are the absconding, and she also, once she was picked up, she had an overdose of meth, heroin, and fentanyl while she was in the Madison County Jail. So I didn't know if she's planning on stipulating or not.
Judge, the
Yes.
sequence of events is that, her probation was revoked based on the absconding, and then she was granted shock probation. And before she got released from custody, she had some cases in some other counties she had to clear up. And that's when the incident happened that Mr. Stockton referenced about the overdose or near overdose. Our position, and we don't deny that happened, and that use of substance would be in violation of her probation. But I would ask the court to consider the initial plan was for her to go to her mom's and work at a factory over in Russell County. I would ask the court to allow us to maybe get her into an in-house rehab and go there instead of going directly home.
Mr. Stockton?
I've been at this 20 years, Your Honor, and I've never had a situation like this where somebody's granted shock and before they can get out, they overdose in the jail. And I'm glad she's still here with us because they had to use Narcan on her because she had the fentanyl and the heroin and the meth. I don't know what gets into people that they use something which may contain fentanyl, but I just don't see how you can reward that kind of conduct.
I regret it. I mean, I really do.
Well, I wish you'd regretted it before you did it.
Well, I wouldn't consider anything but a long-term treatment. Mr. Stockton, if they can find a long-term treatment that she cannot leave or without saying she's absconded. Can you find, what can you find like that, Mr. Sheffield?
Well, there are Kentucky recovery centers. I think, they're all across the state. I think one of those would work. They're 6 months, and if she failed to complete, left on her own, it would be a violation of her probation.
How do you feel about that, Mr. Stockton?
Bill? I think Miss Major's sincere right now that she don't intend to use drugs, but I'm afraid if she has access to them or can leave, that's the problem. Is the Russell County Jail have they got access to the SAP program?
Oh, they don't.
Well,
They won't even let me take classes here.
this is the conundrum that the state government has put us in. They want everybody to get rehab, but they won't adequately fund the SAP program so they can get it while they're incarcerated. They just want to put everybody in rehabs where there's no control. But if that's what the court wants to do, I'll go along with it. I don't like the situation, but I'll go along with it.
I don't like it either. But I'll sign an order putting you in a 6-month rehab that you cannot leave. And if you don't complete that, I will, you're going to be revoked. You understand that?
Yes, sir.
No, nothing. You're just going to get revoked because I'm afraid you'll die on us. Okay. Okay. Thank you very much.
Thanks.
Okay. I've got to take a short break and go down to the grand jury. It won't take very long, and then we'll come back and do Wayne County and Clinton County. Okay. We don't have anything else in Russell County. I guess you can be, y'all can be released.
Okay, let's go down to.
Don't get it, John. We start signing them. Dot Clooney, C-L-U-N-I-E. C-L-U-N-I-E. Yeah, they came out. That one, if I'm missing anything. I'll have it. It was. C-L-U-N-I-E. That's what you want to make sure. It's all lowercase. Yep.
Yeah, I heard. Let's go back on the record here. Let's go to Wayne County. Wayne County.
There we go. It's not letting the video start. It says cannot start video because the host has stopped it.
Okay. Megan, are you the host? Megan? Let's see. Who's got the host machine going here? I don't see that I've done anything to it. Said that the host wouldn't allow it to happen.
No, you're out there.
No, I'm talking Wayne County's camera won't come on. Yeah. Let me call somebody about this.
There you go.
Did you get it?
Yes, sir.
There you are. Okay. Commonwealth versus Stanley Catron. Are you Stanley Catron?
Yes, sir.
It's 21 CR 00120. Mr. Catron, were you born in 1982?
Yes, sir.
Last four digits of your social security number 1354.
Yeah.
Okay, we have a pretrial conference in this case. What do you have to say, Mr. Stockton?
There's a felony plea. He's going to go into drug court in Wayne County, and there's a felony plea, and then it'll be a condition of his plea to complete that.
Motion has been tendered, sir, that say you wish to enter a plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes.
Are you the same person named in indictment number 21 CR 00120?
Yes, sir.
Is your judgment impaired today in any way?
No.
Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you and you believe you're fully informed about your case?
Yes.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution.
Yes.
I'm going to go over those rights, and at the end of that, I'm going to ask you to understand them, okay? You have the right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to a higher court if you lose, the right to require the Commonwealth to prove beyond a reasonable doubt that you are guilty of charges against you. Do you understand that by entering a guilty plea today, you give up those rights?
Yes.
The Commonwealth is going to make recommendations. I may accept any recommendation they have, but prior to doing that, I will await the pre-sentence investigation report to be done by probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and go to trial. Do you understand that?
Yes.
Mr. Stockton, what is the recommendation in this case?
Your Honor, Mr. Catron will plead guilty to trafficking in a controlled substance first degree, first offense, receive 2.5 years sentence. That will run consecutively with the 5-year sentence in 21 CR 84 Clinton indictment. He'll enter and complete the Wayne County Specialty Program, receive credit for time served. He'll be released when he's oriented into that program up there. He'll pay court costs at discretion of the court, maintain gainful employment, and all evidence in this case will be destroyed.
Is that what you agreed to, sir?
Yes, and I've also been assessed up here and made a drug court up here already.
Okay. So that's what we're saying. You need to complete the drug court up there.
Yes. Yes.
Okay. Are you pleading guilty because you are guilty and for no other reasons?
Yes.
Okay. Now, do you understand that by entering this guilty plea, any future convictions could enhance your range of penalties under the persistent felony offender law? Do you understand that?
Yes, sir.
Okay. Mr. Sheffett, do you have a copy of his signature? You can hold up the camera there. Is that your signature on that document there, sir?
Yes.
I'll accept the plea, order pre-sentence investigation report done by probation and parole.
Judge, he may have been sentenced recently in
Has he
Wayne
been
County.
sentenced in Wayne County yet?
Yeah, I've done been sentenced and released here. The only thing's holding me is Wayne County.
Okay, so we can waive the pre-sentence investigation report if he's had one up there, isn't that correct? Okay, I'll waive the pre-sentence investigation report. Go ahead and sign the judgment.
Judge, I believe he's ready to go ahead and start. He has instructions upon his release to contact Ms. Catron with the drug court program to
Okay,
begin.
well, the judgment will be entered today, and as soon as they get a copy of the judgment up there, I guess they can proceed.
All right, thank you.
Okay? Thank you very much. Tanya can answer.
I'll have the female go get her.
Now, we also have been informed that Haley Harbor is up there. Is that correct?
Yes, sir. I'll have her up here.
They've been Harper connection.
I don't know.
Tanya can answer is next,
Okay.
and then Haley Harbor.
8:28. I need that, Tanya can answer.
Okay, while we're waiting for them, we'll go ahead and go to Kyle Traylor. Kyle Traylor. 22 CR 0024. Are you Kyle Traylor?
Yes, sir.
You born in 1990?
Yes, sir.
Last 4 digits, social security number 7347.
Yes, sir.
You're here today for the purpose of arraignment. You have the right to remain silent. You're represented by counsel. Mr. Sheffett. This is Kyle Traylor. The grand jury of Clinton County has returned an indictment charging you with strangulation, unlawful imprisonment, assault, fourth degree, and criminal mischief. Do you understand that?
Yes, sir.
Had he previously been arraigned?
No, Judge, he was scheduled for arraignment last month and it just, I don't know, Wayne County didn't bring him up, or we had some kind of mishap.
Okay, well, you already received the indictment. You acknowledge the identity of your client, waive formal reading, arraignment, enter plea, and not guilty, reserving all pretrial motions, correct?
Yes, Your Honor.
We're gonna schedule this gentleman on for a conference on July 7th. The next court appearance on July 14th. I'm signing a reciprocal discovery order, sir. Commonwealth is going to send your attorney information to help you prepare for your defense, and both of those are a condition of your bond on the 7th and the 14th, okay?
All right.
Okay. Now we got 3 females left, is that correct? We got another male left? Who's left?
Back that up to Melissa.
Who else do we have left in there?
We have Haley Carter and Tanya Canantha.
Alicia White is in the room.
Tanya can answer.
Yes, Your Honor.
Commonwealth versus Tanya can answer. 21 CR 00121, 12 CR 0077, 13 CR 0012, and 13 CR 0014. Ms. Canancio, you born in 1980.
Yes.
Last 4 digits, social security number 5749, correct?
Yes, Your Honor.
Mr. Stockton, what do you have here? Mr. Stockton, your microphone's off. Okay.
Yeah, it's a felony, please, what I have.
Okay. Ms. Canancer, a motion's been tendered that says you wish to enter a plea today. Is that correct?
Yes, Your Honor.
Currently under the influence of drugs or alcohol.
No.
Is this plea freely and voluntarily given?
Yes, Your Honor.
Are you the same person named in indictment number 21 CR 00121?
Yes.
Is your judgment impaired today in any way?
No, Your Honor.
Have you had plenty of time to discuss this matter with your attorney, and are you satisfied with his advice?
Yes, Your Honor.
Okay, review the evidence that the Commonwealth has against you, and you feel like you're fully informed about your case?
Yes.
Okay, you have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. Right to speed trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter to higher court if you lose, and right to require the Commonwealth to prove on a reasonable doubt that you're guilty of charges against you. You understand that by entering this guilty plea, you give up all those rights. Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided. I do not have to accept the recommendation. Prior to accepting a recommendation, I will wait the pre-sentence investigation report from probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. Mr. Stockton, what is the recommendation of the Commonwealth?
Your Honor, Ms. Canancer will plead guilty to trafficking in a controlled substance, first degree, first offense, receive a sentence of 3 years to serve. The Commonwealth opposes probation. She'll receive credit for time served, pay court costs, discretion of the court. All evidence in this matter will be destroyed. Also, she will stipulate to revocation in her probation in case number 13 CR 12, 13 CR 14, 12 CR 77, and 13 CR 16, all in Clinton Circuit Court.
Okay, will this sentence be consecutive or concurrent with those?
Well, by statute, it's supposed to be consecutive since she was on probation when it occurred.
Okay. Is that what you accepted?
That's the thing I really didn't understand. If I couldn't get it, I was wanting it to run concurrent, but I don't guess so.
Yeah, okay.
Tanya, that can't happen on a new indictment if you're on probation.
Are you pleading guilty because you committed the acts charged and for no other reason? Is she a state prisoner now? She's not, is she?
She's not.
I'll have to have a pre-sentence investigation report done by probation parole. And she can come back for sentencing on July the 14th. Okay.
I've had no dirties in 4 years too on probation pro.
Okay. Thank you very much. We'll see you on the
Yes, Your
14th.
Honor.
And they'll
Thank
come
you.
over, they'll come over to meet with you. Okay, now we've got Haley Harbor.
Thanks, Greg.
Haley Harbor. Commonwealth versus Haley Harbor. 22 CR 0034. This is, are you Haley Harbor?
Your Honor.
You born 2000.
Yes,
Last 4 digits, social security number is 6213.
yes.
You're here today for the purpose of arraignment. You have her file. You have a right to remain silent. Mr. Cross is representing you. The grand jury of Clinton County has returned an indictment charging you with complicity to reckless homicide and hindering the prosecution or apprehension second degree. Could y'all hand these back to Mr. Cross? Mr. Cross, you acknowledge the identity of your client. The indictments are on the way back to you. Receive the indictments, waive formal reading and arraignment, enter plea of not guilty, reserving all fifth motions.
Yes, Your Honor.
Okay, now, you'll be scheduled for a conference in this matter on July 7th at 1 o'clock, and then July 14th will be your next court date. I'm going to sign a reciprocal discovery order. And the discovery is on the way back to your attorney. This reciprocal discovery order, ma'am, requires the Commonwealth to provide your attorney with certain information to help you prepare for your defense.
Jennifer, I can't hear him.
Okay,
Your Honor, we have a bond motion on as well.
okay. Okay, go ahead.
Your Honor, Ms. Harbor faced charges in Clinton District Court, posted a $25,000 cash bond, or it was posted on her behalf. Her family did that, also hired private counsel. Ms. Harbor has now got a $100,000 bond. Your Honor, I've heard 2 preliminary hearings on this case. It's a complicity to reckless homicide. Without getting into any of the details, I think that based on the fact that it's complicity to reckless, a $25,000 cash bond would be ample in this case. We've left it in the clerk's office. She's living with her family. She has basically no criminal history.
Where's she living with her family at? Where?
Noblesville, Indiana.
Yeah.
She'd be happy to waive
When was she
extradition.
indicted, Mr. Stockton?
She was indicted last month, and one thing Mr. Cross didn't mention, she's also indicted on criminal abuse, first degree, which is a C felony compared to the reckless homicide, which is a D felony. And also there's a charge being presented today on a wanton endangerment, a supplemental indictment. I don't know if they'll return an indictment or not. So just to
what's the
clarify
word?
the record, the cash probably is enough. I don't know who posted the bond for family posted it. But I don't know how we're going to monitor if she's in Indiana. That's the problem I have, the issue I have. If she
Your
needs to be
Honor,
monitored.
if I may address that, due to the nature of this case, I don't think there's much reason or.
I don't know anything about the case.
Right.
Y'all put me at a disadvantage.
I mean, it's
But I am kind of concerned the fact that she was indicted and hadn't been back down here. When did she come back? Yesterday?
Your Honor, she was indicted. I didn't realize she was indicted until first of the month. She came down and surrendered on Tuesday, drove down here with her family. So she's voluntarily surrendered and been incarcerated since Tuesday. I explained to her family we needed to get her down.
What's the other charge that you said? Was there an abuse charge? What is it?
Yeah, just to give you a little bit of the facts of the case, Miss Harbor and Cody Pergin were at her residence, and she had a 3-month-old baby, which was premature. And Mr. Pergin either fell asleep or passed out on the child and smothered the child to death. So she's charged with criminal abuse because the child was in her legal custody and she allowed the child to die. So that's
Okay,
the
well,
facts.
what I wanted to do is sign a waiver of extradition.
It's fine.
We have a form that we'll send over there to the jail. Ma'am, you agree to waive extradition to come back to the Commonwealth of Kentucky without us having to go through the extradition process.
What does that mean? I'm sorry.
In other words, when we send for you to come back under your bond, you won't make us go through a hearing to see if they can pick you up in Tennessee, in Indiana or any other state and bring you back. You'll agree to come back. We'll send the form over there. I don't really, if she's outside of the state of Kentucky, I'm not really worried about monitoring her that much, except if she will contact the pretrial people if she plans on coming back into the state of Kentucky, Mr. Stockton. In other words, as long as you stay up there. But I don't want you down here gomming around, as they used to say over in Monroe County, okay? So I'll send that order over there and you can sign it, and then we'll recognize the bond from district court, okay?
Thank you, Mr. Stockton. Thank you, Your Honor.
Yeah.
Haley, call me when you get out, okay?
Okay, thank you.
I'll call you Dad.
Okay, Alicia White. Commonwealth versus Alicia White, 21 CR 0079. Are you Alicia White?
Yes,
Were you born in 1986?
yes,
Last four digits, your social security number 1354.
yes.
Okay, you're here today on a pretrial diversion revocation. What do you have to say, Mr. Stockton?
Your Honor, Miss White was pretrial diverted and she was working at Patriot Industries at that time. I thought she'd done pretty well until April. She quit reporting. And then she had also a positive for marijuana at that time. I've talked to Mr. Sheffett. I'd be willing, my understanding is she can go back to Patriot's work. But I'd be willing if she will go in and complete the specialty court to release her when she's oriented, if it's all right with the court. Otherwise, I'd have to have a hearing.
Can you do the drug court?
Yes.
Okay. Well, I'll sign an order referring you over there to that, and they'll do an orientation. When do they meet again, Mr. Stockton, to vote her?
I think it's next Monday.
Okay. Well, we'll get you through the process and back to work as soon as possible. And this is it right here. You know, you need to do this right here to straighten yourself up. I guess really, Mr. Sheffett, what she has is subject to expungement if she finishes. Isn't that right?
What's
Yes,
that,
Your Honor.
Judge?
I said, what this lady, Miss White, has subject to expungement if she'll finish the
Absolutely.
drug court and her time goes by.
Yeah.
You can have a clean record and be working. Just, you know, if you have an urge to take this stuff, it ain't God talking to you. You know what I mean?
Yes.
Okay, well, good luck. I'll sign the order. Wayne County, do we have anybody else there waiting for us?
No, sir, that's it.
Okay, well, thank you very much, and y'all be excused. Let's go to Clinton County now. Clinton County.
We're here, Your Honor.
Okay, let's call Luther Connor up. Connor. Commonwealth versus Luther Connor, 21 CR 0034. Are you Luther Connor?
Yes, sir.
Okay, you born in 2002?
Yes, sir.
Have last four digits of your social security number or what?
0424.
Okay, Mr. Stockton, you're on a pretrial conference. What's going on?
It's a felony plea, Your Honor.
Okay, Mr. Connor, I understand a motion has been filed that says you wish to enter a plea of guilty today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in indictment number 21 CR 0034?
So,
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence which the Commonwealth has against you and you believe you're fully informed about the case?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. I'll go down through the rights, and at the end of it, I'm going to ask you to acknowledge you understand them. You have a right not to testify against yourself. No one can make you say anything. You have a right to be tried by jury. Right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, right to call the Commonwealth, prove on reasonable doubt that you are guilty of charges against you. You understand that by entering a plea of guilty, you give up all those rights. Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence.
No, that's fine.
I do not have to accept any recommendation. Prior to accepting any recommendation, I will rate the pre-sentence investigation report done by probation parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, I'll give you a right to withdraw your plea. Do you understand all that?
Yes, sir.
What is the Commonwealth's recommendation, Mr. Stockton?
Your Honor, upon a plea of guilty possession of a controlled substance first.
We can't see you, Mr. Stockton.
Can you see me now? I'm on Mr. Sheffield's camera.
Okay, well, turn that other camera off in there, somebody. Okay, go ahead. I was looking at the right place for you. Go ahead.
Yeah, it'd be possession of a controlled substance first degree or receive 1 year to serve. He stipulates to the revocation in Clinton number 21 CR 34, 22 CR 1, and shall run consecutively with Clinton Circuit Court 21 CR 34 and 1. The Commonwealth opposes probation and shock probation, receive credit for time served, pay court cost discretion of the court, and all evidence be destroyed.
Is that what you understand, sir?
Yes, sir.
Okay, are you pleading guilty because you are guilty and you did commit the acts charged?
Yes, sir.
Okay, and knowing your constitutional rights, have I explained to you that it's still your desire to give up these rights and enter a plea of guilty to the charges and allow the court to fix your punishment as permitted by law. Is that true?
Yes, sir.
Yeah, you understand it, but enter your guilty plea today. Any future convictions will enhance the range of penalties. You understand that?
Yes, sir.
Okay. Mr. Sheffett, will you hold the document up that's got his signature on it?
Mr. Stockton is getting ready to hand the document over to the clerk for the court.
Is that your signature there, sir?
Yes, sir.
Okay. Well, I will accept a plea, order pre-sentence investigation report to be done by probation and
That's
parole.
not the wrong file or something.
And we will come back here on the 14th for your sentencing, okay?
All right, thank you.
Okay, thank you. Travis Flowers. Travis Flowers. Commonwealth versus Travis Flowers. Are you Travis Flowers?
Yes, sir.
This is 22 CR 0010. Mr. Flowers, what was your year of birth?
1993,
Last four digits of your social security number?
5823.
Okay, this is, says on the docket, a motion to consolidate a motion set for trial and motion vote bond. What do you have to say, Mr. Stockton?
We have a felony plea, Your Honor.
Okay. Mr. Flowers, I've just been informed that you tendered an offer that says you wish to enter a guilty plea. Is that correct?
Yeah.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given? Are you the same person named in indictment number 22CR0010?
Yeah.
Is your judgment impaired today in any way?
No.
Okay, have you had plenty of time to discuss this matter with your attorney, and are you satisfied with his advice?
Yeah.
Have you viewed the evidence the Commonwealth has against you and you feel like you're fully informed about your case?
Yeah.
You realize that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have the right not to testify against yourself. No one can make you say anything. Right to speedy trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witness in your favor, the right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty charge against you. You understand that, but entering a guilty plea today, you give up those rights. Do you understand that? Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept the recommendation. Prior to accepting the recommendation, I will wait a pre-sentence investigation for it to be done by probation and parole. In the event I do not accept the Commonwealth's recommendation, decide to impose a harsher punishment, I will give you the right, or you have the right, to withdraw your plea of guilty and proceed to trial. Do you understand that? Okay, Mr. Stockton, what do you have?
Your Honor, Mr. Flowers will plead guilty to trafficking in a controlled substance, first degree, Class D felony, receive a sentence of 5 years to serve. Commonwealth opposes probation and shock probation, pay court costs discretion of the court, and all evidence in this case will be destroyed.
Is that what you agreed to, sir?
Yeah.
Has anyone, including your attorney, threatened or coerced you or offered you anything in return for this plea? Are you pleading guilty of your own free will because you are guilty and for no other reason?
Yeah.
Okay. And no constitutional rights, as I've explained to you, is it still your desire to give up those rights, enter a plea of guilty, and allow the court to fix your punishment? Is that true? Do you understand that any future pleas of guilty or convictions on felony could be enhanced by virtue of this plea under persistent felony offender law? Do you understand that?
Yeah.
Okay, Mr. Sheffield, will you hold the document up with his signature on it? Is that your signature on there, sir?
Yeah.
Okay, I will accept the plea order pre-sentence investigation report done by probation and parole, and we will send you on the 14th of July. The probation and parole people will be over to see you the next day. Okay, thank you very much. Ferdinand Gerger. Ferdinand Gerger.
Yes, sir.
This is 21 CI 0090. We're here for a pretrial. Mr. Gerger, what's your year of birth?
12/16/1958.
1958. Okay. What are the last 4 digits of your social security number?
5474.
Okay, we're here for pretrial conference. What does the Commonwealth have?
We have a misdemeanor plea, Your Honor, with a judgment.
Okay. Mr. Gerger, a motion has been tendered that says you wish to enter a plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes.
Are you the same person named in indictment number 210009?
Yes.
Have you had plenty of time to discuss this matter with your attorney, and are you satisfied with his advice?
Yes, I am.
Have you reviewed the evidence the Commonwealth has against you? Do you believe you're fully informed about the case?
Yes.
Okay, you understand that you do not have a guilty, you do not have to enter a guilty plea. You have certain rights under the Kentucky and United States Constitution. I'm going to go over those rights with you, and then I will ask you to acknowledge you understand at the end of that. You have a right not to testify against yourself. No one can make you say anything. Right to speedy trial, but jury, the right to be represented by counsel at your jury trial. You have a right to confront and cross-examine all witnesses called to testify against your right to produce evidence, the right to call witnesses in your behalf, and have a process issued to compel their attendance. You have a right to appeal this matter to higher court if you lose, and a right to part of the Commonwealth proving on a reasonable doubt that you're guilty of charge against you. That you understand by entering a guilty plea today, you give up all those rights. Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. If I do not accept the recommendation, I will allow you to, and decide a harsher sentence, I will allow you to withdraw your plea and go to trial. What is the Commonwealth's recommendation?
Your Honor, Mr. Gerger will plead guilty to possession of drug paraphernalia receive a sentence of 12 months, probated for 2 years. He will agree to reimburse Clinton County for the extradition cost of $597.77. He'll pay $75 a month on that. First payment due within 45 days. And after that, $75 per month. Restitution subject to a 5% clerk's fee. He'll receive credit for time served, pay court costs at discretion of the court, maintain gainful employment. All evidence in this case be destroyed.
What's the court cost? $155, and I'll allow you to pay that at $30 a month in addition to the 70 that you're doing on the restitution. So it'll be about $100 a month. You should be able to manage that, do you think?
Yeah.
Okay, so I will accept the plea. It's a misdemeanor plea. So I can go ahead and sign the judgment. Hold that up, and show him his signature, make sure he signed that. Now, okay, Mr. Stockton, there's one thing I am concerned about though, is he's going to leave the jurisdiction of the state on a misdemeanor.
My understanding is, according to Mr. Sheffett, and I'll make him pay it. If he doesn't, he's supposed to be living here.
Yeah, I'm gonna be living with my sister right here in Albany.
I want that a condition of his probation, that he'll live within the state of Kentucky.
Okay.
Okay, because we're not going to, extradition on a misdemeanor is questionable. You know what I'm saying?
I agree.
So he shall not leave the state of Kentucky during this time period without specific permission. Okay, I'll go ahead and sign that. And when can the document will allow him to be released today? Is that correct, Mr. Stockton?
Yes.
I'll go ahead and sign a release, sir, and let you be today. And you remember, you got those two payments that total around $100 a month. And you need to pay them 30 days from day the first one, okay? Gary Latimer. Gary Latimer. Commonwealth Kentucky versus Gary Latimer. 21 CR 0091. Are you Gary Latimer? Are you Gary Latimer?
I am.
Okay. What do we have here, Mr. Stockton?
Well, Mr. Latimer was found not criminally responsible by KCPC, and me and Mr. Sheffett still working on the case. We hope to have a resolution of it by the 7th. Is that correct, Mr. Sheffett?
Yes, Judge. While competency has definitely been a concern, I met with Gary Monday, and I'm not so sure that competency is a concern at the moment. I know that's something that fluctuates.
Competency seems to improve considerably when there's the finding of lack of criminal responsibility.
Well, I think he's gotten on some medication that's helped him.
Okay. So we'll be back here on the 7th for, you want to come back on the 7th for negotiations, and then
Yes, Your Honor.
and then on the 14th for the next court appearance, okay? Okay, thank you very much. Your attorney will be in contact with you. Shannon Mercer. Shannon Mercer.
Krause's, I need that one. Yeah.
Okay, so motion about the.
Was very dry.
Commonwealth versus Shannon Mercer, 20 CR 0054. Are you Shannon Mercer?
Yes, Your Honor.
Born in 1975.
Yes, Your Honor.
Last 4 digits social security.
We notice it for next month.
55. We're here today on a probation revocation. You're represented by Mr. Cross. Mr. Stockton, what do you have to say?
Mr. Mercer has a 5-year sentence on DUI 4, and he's been on probation. And during the time of his probation, he's tested positive on May the 10th for methamphetamines. On May the 6th, he failed a report. And on May 17th, he was confirmed positive for methamphetamines, but he had a diluted sample on his drug screen.
Your Honor, Mr. Stockton and I discussed this case yesterday. He mentioned possibility of rehab in lieu of revocation. He was talking about a long term. I told him I thought Mr. Mercer might not agree to that, but I candidly have not had an opportunity to talk to Shannon because I didn't know how long we were looking at. While we're all here, Mr. Stockton, what would you have in mind on a?
Your Honor, I would ask it, at the minimum, he go to a 6-month rehab, or if he wants to stipulate on the revocation, he might be shocked out in rehab, but
Yeah.
he's going to have, I've known Shannon for a long time. He can function well. He does good. When he's sober, he's the nicest fellow ever was, but he's got to get off this stuff, and he's going to have to do whatever it takes.
Shannon, would you agree to go 6 months and not be revoked? Because otherwise you're going to get revoked.
Yes, Mr. Cross, that'd be fine.
Okay. We'll do that, Your Honor.
If that's all right with the court. If not, we need to go on. We'll have a hearing.
I will say this about Mr. Mercer. Mr. Stockton's given a pretty accurate portrayal of him. He's had a lot of things go on in his life recently, the most significant being the loss of his longtime companion who died suddenly. And he's really struggled, and emotionally and otherwise.
Yeah, I'll go ahead with a 6-month with being an institution that if he leaves there, he will be considered to be absconding. And he'll know what will happen as far as the revocation. I give him the opportunity to
Will
work.
probation and parole arrange that, Your Honor?
Yeah, they said they can arrange it.
Good.
So the first,
Shannon, they'll get you in.
first bed date available, we'll do that. And Mr. Mercer, this is kind of the last deal on it. Do you understand what I'm saying?
Yes, I do have a question. Can my family help get me a bed?
No, we'll do it through probation and parole.
That's
Okay.
what they get paid to do, Shannon. They'll do it.
Here,
I'll give you a call.
you know, the thing
I
about
think
it.
that's my criminal docket, Your Honor. I'll be excused if I may be till after 1.
Absolutely,
Thank you.
absolutely, yeah. Okay, thank you very much. William Moore. Commonwealth versus William Moore.
That's a termination from drug court.
20 CR 0013 Commonwealth versus William Moore. Are you William Moore? Are you William Moore? You need to say something. Are you William Moore? It's the microphone appears to be.
Yes, sir.
Okay, I can hear you now. Mr. Moore, were you born in 1988?
Yes, sir.
Last 4 digits, social security number 4577.
Yes.
Are you here on a pretrial diversion revocation? What do you have, Mr. Stockton?
Your Honor, Mr. Moore was in the Clinton County Specialty Court Program. He had a 3-year sentence on possession. He had multiple positive tests for meth, I think that 6 in all. And finally, he absconded and he was terminated from drug court. So we're asking for his diversion.
You stipulate to that, Mr. Sheffett.
Your Honor, Mr. Moore's presence at the jail escaped me, so I have not talked to him. Under ordinary circumstances on a drug court termination, I would stipulate, but I hate to do that without having had a conversation with Mr. Moore.
July the 14th. I mean, I don't really see what could change about this situation. It's just costing the citizens
Well,
of Clinton County hundreds of dollars, but that's.
It's
okay.
unlikely, but there have been situations.
Cody Owens is next.
So am I supposed to mention it to the judge?
Cody Owens. Commonwealth versus Cody Owens, 22 CR 0031. Are you Cody Owens?
Yes, sir, Your Honor.
Were you born in 1987?
Yes, sir.
Last 4 digits, social security number 5351.
Yes, sir.
Okay, what do you have, Mr. Stockton? It says a pretrial.
It's a felony plea, Your Honor.
Okay. Mr. Owens, a motion has been filed that says that you wish to enter a plea today. Is that correct?
Yes, sir, Your Honor.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in the indictment, number 22 CR 0031?
Yes, sir.
Is your judgment impaired today?
No, sir.
Have you had time to discuss this matter with your attorney, and are you fully informed?
Yes, sir, Your Honor.
Have you reviewed the evidence the Commonwealth has against you?
Yes, sir.
Okay, you understand that you do not have to enter a guilty plea today. You have
Yes,
certain rights under the Kentucky and United States Constitution. I'm going to read through these rights and ask you to acknowledge that you understand them at the end of the list, okay? You have the right not to testify against yourself. No one can make you say anything. Your right to speed trial by jury, your right to be represented counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, right to call witnesses in your favor, right to appeal this matter to higher court if you lose, and right to require the Commonwealth to prove it on a reasonable doubt that you're guilty charged against you. Understand that by entering this plea today, you give up those rights. You understand?
Yes, sir.
that? Okay, now I may consider the Commonwealth's recommendation, but I may apply any range of sentence allowed by law. I do not have to accept any recommendation. Prior to accepting any recommendation, I will wait the pre-sentence investigation report done by probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea and proceed to trial. Mr. Stockton, what is the Commonwealth's recommendation?
Your Honor, Mr. Owens will plead guilty to burglary second degree, receive a sentence of 10 years. He'll enter and complete a long-term treatment facility that's going to be found by DPA, but that'll be in consultation with the Commonwealth and our approval. As of entry of this plea, the defendant shall be incarcerated for 151 days. He'll remain incarcerated until bed date is found and scheduled. The balance of the sentence will be probated for 5 years. He'll pay court costs at the discretion of the court, obtain and maintain gainful employment. And he also have no contact with the victim and shall not be back on the premises of Albany Manor without permission of his probation officer.
What's the court cost here? $155. You can pay that $30 a month. First payment being 30 days after you get out of jail. Is this what you've agreed to?
Yes, sir, Your Honor.
You understand that you understand that this conviction could be used in the future to enhance penalties if you have any other felonies. You understand that?
Yes, sir.
Are you pleading guilty of your own free will because you are guilty and for no other reason?
Yes, sir.
Mr. Sheffield, will you hold that signature up to the camera there?
Okay, go back to the office.
Is that your signature on there, sir?
Yes, sir.
Okay, well, I'll accept the plea order, pre-sentence investigation report be done by probation parole. Bring you back on July 14th for sentencing, okay?
Okay, thank you.
Cody Perigin. Commonwealth versus Cody Perigin.
I don't believe I had him now.
Are you Cody Perigin?
Yes.
Conflict clause.
CR 0035. Were you born in 1996?
Yes, sir.
That's 4 digits of social security number 2329.
Sir.
Yeah, you're here for arraignment. You have a right to remain silent. You have your attorney here present with you, Mr. Sheffield. Grand jury of Clinton County has returned an indictment charging you with reckless homicide. Do you understand that charge?
Yes.
The bailiff is going to deliver that back to you, Mr. Sheffield. You acknowledge the identity of your client, receive the indictment, wait formal reading and arraignment, and plead not guilty, reserving all pretrial motions.
Yes, Your Honor.
Hey, Mr. Perigin, I'm signing a reciprocal discovery order. The Commonwealth's bringing certain information back to your attorney to help you prepare for your defense. Have a negotiation day on July 7th, and the next court date on July the 14th, okay?
Judge, if we could take a moment to review his bond.
Surely may.
I believe his bond is currently 100,000 cash. I don't know if the Commonwealth is also seeking additional indictments on Mr. Perigin. Is that, or is that just Ms. Harbor?
It was just her, but he's also charged with criminal abuse I'll agree to the same bond on him as you gave Miss Parrott and Miss Harbor.
I'm not finding that he's charged with criminal abuse.
He's not, because he didn't have legal custody of the child.
Okay.
And I think he was already indicted on wanton endangerment.
What is the bond that she's under?
25,000 cash. What you changed?
Your Honor, he was, after his preliminary hearing, his bond was amended to 50,000 surety bond with home incarceration. And he had been out on that until served with this indictment warrant. I don't think there had been any complaints about his behavior while he was out. I would ask the court to allow that bond or reinstate that bond.
Yeah, just to clarify the record, I misspoke a while ago. I was incorrect. He also was indicted on wanton endangerment today.
Okay.
Yeah.
Was
So
he,
he has-
was he working while he was out on bond?
Your Honor, I don't think he had been out long enough to probably get a job. He was probably out a couple weeks. Because initially he was incarcerated on this until after the evidence was heard at the preliminary hearing.
Well, does he have somebody that can make a $25,000 cash bond? That's what she made, right?
I would suspect the answer is probably no. But he, unlike Ms. Harbor, he's a local citizen with significant local ties. He's not a flight
Does he
risk.
have, what about a property bond? Does he have somebody can make a property bond?
He's shaking his head, yes. I'm not sure how much, though.
Well, I'll do a $25,000 property bond, which means that he has to have $50,000 worth of cleared property to make the $25,000 property bond.
So what, 25 cash or 2 times property?
25 cash or 2 times property, yes. And I want an ankle bracelet on, but he can go to work, church, or the doctor. So he can get a, work, church, or the doctor. I don't want him out, as I used to say, Monroe County, gomming around anywhere. You know what I'm saying? Okay. Thank you. Michael Stinson. Michael Stinson.
Supposed to be. May not be in custody.
Michael Stinson, is he at the jail? Are you Michael Stinson?
Yes, sir.
Okay, this is 22 CR 0027. Mr. Stinson, were you born in 1976?
Yes, sir.
Last 4 digits, social security number 2952.
Yes, sir.
We're here for a pretrial conference. What does the Commonwealth have to say?
I was waiting to hear back from Mr. Sheffield on this case.
The last offer that you made was 5 years to serve is my memory, and
That's correct.
We don't accept that offer. I don't know whether there's room. We're certainly open to negotiation.
What is the charge?
He has 2 cases, Your Honor, and 21 CR 134. He's got trafficking second, PFO second, 22 CR 27. He's got possession of a handgun for convicted felon. Was he indicted today, Larry? And he was also indicted on a new case today, promoting contraband at the jail. So
Okay,
we'll
well,
have 3 felony cases.
Okay, let's just set a trial. Set a trial.
Judge, can we?
No, I'm not going to, I'm finished with pleas on these firearms by convicted felon. I'm finished on those. I'm just going to see.
What I was saying, Judge, is that I'm unfamiliar with the case that he was indicted on today. If we could.
Okay, we can set a negotiation on July 7th. And the next trial is the 14th. But I'm telling you, if they've got a good case on firearm and convicted felon, I'm going to start letting juries decide about that. There's too much violence in this country for felons to be fooling around with firearms. They know not to, and I'm tired of it here. Okay, not saying that he did. I'm not saying that he did. Okay, Eric Story.
What about my bond, sir?
You don't have a bond until then, sir. Okay, Eric.
Judge, on Mr. Stinson, his bond was revoked early. He missed court and.
Right. That's why he doesn't have a bond until then. Okay.
I was asking.
Eric Story. Next case. Commonwealth versus Eric Story, 21 CR 0019. Eric Story.
Yes, sir.
Okay, this is your year of birth, 1973.
Yes, sir.
Last four digits of social security number 3700.
Yes, sir.
Okay, you're here on it says on the docket, shock probation revocation. What does the Commonwealth have to say? Got your microphone, Mr.
There we
Stockton.
go. I believe Mr. Story is on a 7.5-year sentence and he absconded on his probation. He was released December the 2nd, 2021. And I don't think, and he was granted shock, I'm sorry, December 16th, 21. And he never contacted probation parole and he's been absconded now for 7 months. So I don't know if he wants to stipulate or not.
Your Honor, we don't dispute the factual allegations set forth by the Commonwealth. We would like the court to consider alternatives to revocation such as long-term treatment or drug court or other.
There's just not much I can do when I do the shock probation and somebody just takes off and absconds. I don't have very much choice. So I will revoke the shock probation. Okay, thank you very much. Jason Taylor. Commonwealth versus Jason Taylor. Are you Jason Taylor? Okay, this is 22 CR 0028. Were you born in 1980, sir?
Yes, sir.
Last four digits, social security number 2813.
Yes, yes, sir.
What do you have, Mr. Stockton, on this?
We have a plea, Your Honor, I think, don't we, Mr. Sheffield?
Yes.
A motion has been tendered, Mr. Taylor, that says you wish to enter a guilty plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes, sir. I believe so.
Are you the same person named in the indictment?
This one me and Mr. Shep talked about.
Yeah. Is your judgment impaired today in any way?
Yes, sir.
Have you had plenty of time to discuss this matter with your attorney, and are you satisfied with his advice?
If it's what me and him talked about.
Okay, well, we'll get to that up to this point, but you're satisfied with his advice, subject to you hearing what the plea agreement is. Is that correct?
I reckon so, yeah.
Yeah. Have you reviewed the evidence the Commonwealth has against you, and are you fully informed about the case?
I think so.
Okay, now you have certain rights under the Kentucky and United States Constitution. I'm going to go over these rights with you. And
Okay.
I'm going to, at the end, I'll ask you if you understand them. If you don't, you can ask me to read them again, okay? You have the right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses yourself and have process issued to compel their attendance. You have a right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. Did you understand by entering a guilty plea today, you give up those rights? Now, the Commonwealth is going to make a recommendation that they'll read in a few minutes. I want you to understand that I may apply any range of sentence provided by law. I do not have to accept the recommendation, but prior to determining whether I accept the recommendation, I will await a pre-sentence investigation report done by probation and parole. In the event that I do not accept the recommendation and decide to impose a harsher sentence, I will allow you to withdraw your plea and go ahead and stand trial. So what you agree to is the most you can get unless you change your mind about that. Mr. Stockton, will you read the recommendation and see if this gentleman agrees, okay?
Your Honor, in indictment number 22 CR 28, the defendant shall plead guilty to trafficking in a controlled substance, first degree, first offense, a class D felony, receive a sentence of 5 years. Upon a plea of guilty to the information indictment, which has been furnished here, 22 CR be assigned a number for the charge of possession of a controlled substance, first degree, and referenced in Clinton District Court number 22 CR 22 F 38, the defendant shall receive a sentence of 1 year. Those two sentences shall run concurrently for a total of 5 years. They'll be pretrial diverted for 5 years, supervised, He'll enter and complete the Clinton County Specialty Program. He'll receive credit for time served, be released at orientation. She'll pay a court cost at discretion of the court. He'll be required to maintain gainful employment, and all evidence in both cases will be destroyed.
So this is a pretrial diversion and not a straight felony plea?
That's correct, Your Honor.
Okay, sir, I'm going to modify what I said a few minutes. I got a few other questions I've got to ask you. Have you previously been diverted in the last 5 years?
Not that I know of. Okay.
Well, you would know of it if you had.
I mean, I've not been in no trouble. So.
Okay, well, that's good. You have any felony convictions in the
I
past?
had it right there, but I may have misplaced it.
No.
Are you currently on probation?
No.
You understand if you fully complete the diversion program, the charges will be dismissed, pretrial diverted, and you can have your record expunged. You understand that?
That's what we talked about, I think.
Okay.
It was fine.
However, Mr. Stockton, your microphone is on now, okay? Okay. If you successfully complete the pretrial diversion program, it will be dismissed and you can be expunged. However, if you violate the terms of pretrial diversion, you'll be brought back in front of me, and if I believe the violation is serious enough, I will revoke your pretrial diversion, order a pre-sentence investigation report done by probation and parole, and you'll be sentenced according to the agreement. You'll be a convicted felon then, and any future convictions you might have to be enhanced. You understand that?
Yes, sir.
Okay, are you pleading guilty to your own free will, understanding the terms of the pretrial diversion?
Yes, sir.
And then you have the document there with you, Mr. Sheffield. Can you hold it up? Let this gentleman take a look at it. Is that your signature on there, sir?
Yes, sir.
Okay, well, I'll go ahead and sign the pretrial diversion agreement today. Now, when does he get out of jail then, Mr. Stockton, Mr. Sheffield, today? Has he got something else to serve? Mr. Stockton, your microphone's not on.
When he's oriented for drug courts, Your Honor, he'd be.
So I'll sign that order. They'll vote you into drug court, do your orientation, and I'll let you out that day in time to get cleaned up to go to the drug court. Okay, it shouldn't be that long, just a few days. Okay?
Okay. Thank you, sir.
Thank you very much.
Thank you.
David Ray. David Ray. Commonwealth versus David Ray, 22 CR 0011 and 22 CR 0030. Mr. Ray, were you born in 1975?
Yes, sir.
And the last 4 digits, your social security number is 7615. Is that correct?
Yes, sir.
We appear to be here on a pretrial conference. Mr. Stockton, what do you have to say?
We have a felony plea, Your Honor.
Okay, it's a felony plea and not a diversion, correct?
That's correct.
Okay.
That's
Okay,
my fault on the last one.
that's okay. Mr. Ray, a motion has been tendered. We were just advised, says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yeah.
Are you the same person that was named in these two indictments, 22 CR 0011 and 22 CR 0030?
Yeah.
Have you discussed this matter with your attorney, and are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you? Feel like you're fully informed about your case?
Yeah.
Now, you have certain rights under the Kentucky United States Constitution. Before I can accept a plea, I need to know you understand those rights. I'm going to go down through them, and at the end, I'm going to let you acknowledge that you understand them. You have the right not to testify against yourself. No one can make you say anything. You have the right to speed trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witness in your favor and have process issued to compel their attendance. You have a right to appeal this matter to higher court if you were to lose. You have a right to require the Commonwealth to prove beyond a reasonable doubt that you are guilty of charges against you. Do you understand by entering a guilty plea that you give up all these rights? Do you understand that?
Yes, sir.
And I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept the recommendation. Prior to considering the recommendation, I will await the pre-sentence investigation report done by probation and parole. In the event that I do not accept the recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea and go to trial. Do you understand that?
Yes, sir.
Okay, Mr. Commonwealth Attorney, what is the agreement?
Your Honor, Mr. Ray will plead guilty in 22 CR 11 to the charge of promoting contraband. He'll receive a sentence of 5 years. In indictment 22 CR 30, he'll plead guilty possession of controlled substance first degree, receive a sentence of 2 years. Those two sentences shall run consecutively for a total of 7 years. He will enter and complete a long-term treatment facility agreed upon between Defense Counsel and Commonwealth. Defense Counsel's social worker shall provide the name of the facility and arrange a bed date. As of the entry of this plea, the defendant has been incarcerated for 87 days and shall remain incarcerated until the bed date is scheduled. He'll be probated for 5 years, receive credit for time served, pay court costs discretion of the court. He will obtain and maintain gainful employment once he's released on supervision, and all evidence in these cases will be destroyed.
Okay, I'll have a pre-sentence investigation report done, and you come back on July the 14th for your sentencing. And hopefully shortly thereafter, you can get into a rehab situation, get out of there. What's the court cost about? The court cost is $155. What I'm going to do is wait till you finish the rehab, and then you can pay it $30 a month, because you'll have a little transition period to get back on your feet, which I hope you do. Okay.
Thank you.
Okay, that concludes this matter. Okay, is there anything else?
Your Honor, there's 2 matters that hadn't been called.
Okay, do we have anything else in Wayne County? Who you got there?
Ricky Phillips.
Yeah, he has an arraignment, Your Honor, it needs to be done. The other case, the pretrial with Coleman Hurt, was continued.
Okay, I'll call Ricky Phillips case. I inadvertently skipped over that. Commonwealth versus Ricky Phillips, 22 CR 0033. We're here for the purpose of arraignment. Are you Ricky Phillips?
Yes, sir.
Okay, were you born in 1985?
Yes, sir.
Last 4 digits, social security number 3824.
Yes, sir.
Okay, you have a right to remain silent. You're represented by the Office of Public Advocacy. The grand jury of Clinton County is returning an indictment charging you with burglary in the 2nd degree and criminal mischief in the 3rd degree. The bailiff is going to bring Mr. Sheffitt copies of the indictment. Do you acknowledge the identity of your client, Mr. Sheffitt? Receive the indictment, waive formal reading and arraignment, enter a plea of not guilty, reserving all pretrial motions. Do you do that, Mr. Sheffitt? You're frozen, Mr. Sheffitt. Speak to me. Well, there's 2 of you, Mr. Sheffitt's in the courtroom now. It's amazing. And they said you couldn't be 2 places at one time. Next time he wants to continue it, we remember that, Mr. Doctor. Yeah. I'm signing a reciprocal discovery order, Mr. Phillips, so that you can get the evidence to help prepare your defense. What's the bond here this gentleman has?
Your Honor, I've actually filed a motion to revoke his bond in the other case that Mr. Hurt's on, because this case has arisen after he was indicted on the other case. He was out on bond. So
Okay.
I'd like to take that up when Mr. Hurt's available.
Okay, well, what we need to do then is wait until that's decided. Let's have him come back on the 7th for negotiation on both of these cases, and see if there's any possibility of doing a global resolution to this with attorneys on the 2 cases. And then you come back and report here on the 14th. And if we can't reach an agreement, then we go ahead and you can elect which one you want to go forward to, Mr. Doctor. Now, Wayne County, do you have anybody else? Thank you, sir. Do we have anybody else there, Wayne County? Any forgotten soul that we've not gotten to?
Your Honor, we have one other matter. I don't know if the defendant's.
Is it in Clinton County Jail? Is the person in Clinton County Jail?
I don't know if he's been released or if he's still there. It's Sherman Hensley.
He's actually here. He was picked back up on Monday afternoon.
Okay.
Well, let's bring him in here.
All right, give us just a second.
Sherman Hensley. Is this one of yours?
Well,
He was.
It was, I forget the name of the man.
Yeah.
And this motion is related to supervision. I think it's a revocation motion.
We'll get him here in front of us to see what it is here. What's his case number? Y'all got a case? number?
Motion's for his benefit, so I don't know. He might object anyway.
It's 21 CR 27
21 CR 00027,
and 00038.
30 or
38.
27 and 38.
Yes.
Tracy said I need to revoke him if I can. I didn't even know he was in jail.
Wait. Your microphone's on. Well, we finished down till 1 when we did this. We finished till 1 after this case. Whoop, whoop. Okay, let's go back on.
Okay.
Commonwealth versus Sherman Hensley, 21 CR 0027, 21 CR 0037. Is that right? 38. Okay, are you Sherman Hensley? Okay, and your attorney, Office of Public Advocacy is here with you. Could you go back and see if you're unlocked back there yet?
My battery ran out.
You don't have a plug-in?
It's in my car.
Okay.
So I thought I had that.
Mr. Stockton, do you have a battery plug-in that you can lend this guy? What
I don't
about
have
mine? Come over here and see if mine will fit you. Is this, it's the same kind?
I'd say that probably will. Of course, I still gotta get probably all back on.
Ain't worry, man.
Just go back there where Mr. Stockton is. You shared his with him there.
That sure made the difference.
Okay, your attorney's back there with the Commonwealth attorney now. Yeah, what's going on here, Mr. Stockton? Tell me.
I'm trying to clean up a mess, Your Honor. Mr. Hensley was originally, he entered a plea. He was to be shock probated after 60 days and go into the Clinton County Drug Court Program. Well, what happened was he was referred to the drug court program, and Mr. Krause went ahead and got him released. I don't know. He probably conferred with me and I probably got mixed up. I don't know. But anyway, he was released prior to 60 days and a shock probation motion was never entered. So I'm asking, I think the best way to clean the situation up is we just enter an order that he be on probation rather than shock probation. That way the Department of Corrections is one complaining that there wasn't a shock probation motion entered, order entered, or we can just do a shock probation order, however the court wants to do it. But he'd have to be in custody to do the shock probation order, and he's already in custody, it looks like, for a drug court violation. It's a mess.
Judge.
Yeah, I was in ATV accident, Judge, and I've been in UK hospital and
Wait a second.
Yeah, we don't need any testimony right now.
Judge, I don't think there would be any harm in entering an order of probation. On Mr.
Well, the problem is whether they'll recognize my jurisdiction over the case with you. So I'm going to say the truth in which it inadvertently was not entered. Okay, and we had made a judgment from the bench, but that it passed by and didn't get a signature out of the shock probation. Just include that in the order. And then now let me tell you something. I don't know what kind of accident you're in or whatever.
Yeah.
But you need to live at the foot of the cross on this thing. You don't need to be taking anything.
you don't need to be violating. And is he going into drug court, did you say, or what's he gonna do?
He's already in drug court, and I guess he's in jail on a drug court violation. I just not aware of what it is.
Is that right? Don't tell me what it is, but you're in on a violation.
Yeah,
I don't want to know about what it is. How many days you got to serve on the violation?
Don't know.
we don't know that. We don't know, Your Honor.
Well, when the drug court meets, they'll determine that. The team will decide. next
Okay.
week.
Okay, well, I'll go ahead and enter that retroactive shock probation thing, and then you can continue to deal with the drug court, okay?
Okay.
Okay, it's a good day for you. If you get past Judge Costello now, you have a fresh start. If you don't, I'll see you again soon, okay? Okay, thank you very much. Is there anybody else at the Clinton County Jail?
No, Your Honor.
Okay, well, y'all are excused. Thank you very much. Mr. Stockton, do you have anybody else to come before us today or
No, Your Honor.
finished? Okay, well, thank y'all very much, and we'll reconvene at 1 o'clock for the civil docket and or the other things we need to do. Okay. Owen versus Owen. Manis versus Manis. Carter versus Carter.
Judge, right before court, Mr. Carter called Kathy at child support, so it's in Somerset. Didn't have a ride down here, vehicle broke down, and so that's what he said. I don't know, we're prepared to put Kathy on for testimony or continue it the next month.
What's the situation? Let's put her on and let's hear what the situation. You swear the testimony about to give us the truth, whole truth, nothing but the truth.
I do.
State your name,
Kathy Martin,
by whom are you employed,
Clinton County Child Support,
and what's your position?
caseworker.
Are you familiar with the case of Letitia Carter versus Clifton Carter?
Yes.
And how are you familiar with this case?
Caseworker.
And how many children are there in this case?
There are 3.
Okay, and to your knowledge, has Mr. Carter paid child support in the past?
Nothing on that one.
Not that you know of, and to your knowledge, is he employed at this time?
No, he says he's not.
Okay, and have you been contacted by Letitia regarding the child support, the mother?
Yes.
Okay, and what has been her desire for this case?
She would like him to pay child support. She says that she thinks he's working somewhere, but we checked the right lawyer. And they say it's not there.
And how old are the 3 children approximately? Not sure. No, this is a step in this case. So that's kind of the situation.
What's the rearage?
There's no marriage, it's just a set child support.
It's just a set today.
There's 3 children
Uh,
and you have no idea what the oldest, how old the oldest one is.
I'm not sure. The said that he's working the case.
Well, were they ever married?
Yes, never married.
Is there a divorce decree?
I don't think so.
Would know.
Or they're separated.
Separated.
So they're not divorced. So you want to impute minimum child support to him?
That's gonna be our ask if he was here.
Well, I'm gonna do that. I mean, I don't buy the thing that he couldn't get here, you know, I don't buy that. So he couldn't be here today, but he never has paid anything any other time, you know, so. Are you attempting to go back on him?
If need be, yes, absolutely.
But this is just perspective.
Right, right, if he voluntarily employed or something.
Yeah,
Check
okay.
it back to you, so we don't need to be here.
Okay. Cabinet versus Mendoza.
Judge, we have an agreement at Matt, he's gonna follow us down, he's gonna call it to the child support office. to look at the order.
Keith Markham.
Judge, we have an agreed order in this case.
That it?
That's it, Judge.
Okay, thank you very much. Now, you represent the respondent, is that correct?
Yes, I
Are you Lois Rogan? Logan, Lois? And you're Terry Logan? Do you have an attorney? Okay, tell us what your problem is.
Your Honor, this is our motion to show cause in the property agreement which was entered February 7th, 2018. Mr. Logan was to pay any tax arrears for the years of 2011, 2012. And what's happened is since then, he doesn't file taxes and they intercept hers. So they have intercepted her taxes for $1,325. And the order provided that he was to reimburse her.
And that's all this is, I've got it all in work, I got people working on the taxes, trying to get all this taken care of. We're just, it's taking time, and the reason she needs to, I've called the IRS, it's my tax people's call, and she has to fill out the paper, and get her name on it. So I've tried everything to get her off of it, they won't let me do it, they say she has to. Talk to the IRS, everybody that I need to talk to, she needs to fill that form out to get her name off.
Well, that's good. Are you gonna do that?
We're not aware of any form. If he would send us that form.
Well, I mean, he can provide it to you today. You got it with you?
No, I don't have it in the IRS, and they would have to request it.
Do you got a letter from the IRS or anything?
No, I just back home and talk to them.
Yeah. Well, here's the way I look at it. You're under obligation to see what you can do to get off the tax situation. But if they've intercepted $1,325 of her money and applied it to your tax liability, you receive that much benefit. And if you are able to get your taxes redone, you'll get a refund of that amount.
They're working, like I said.
Well, I understand. You understand what I'm saying? So you pay her $1,325.
Well, it's gonna take me a little while, because the guy I was working for,
Well-
he just quit
Well, where do you live?
in Bowling Green.
Well, I tell you what, you have $1,325 paid to her by August. I mean, by July 14th. Okay.
We're also asking for $500 attorney fee.
How many times have you been here?
Several.
Yeah, well, $500 total for all of them. Is that what you're saying?
No, for this time,
Well, what have you been paid previously?
last year.
How much?
I would have to look.
$500.
Yeah.
That's what she gets every time.
Well, he has reason to remember
It's
that.
probably was five, I'm thinking, I don't have the order in front of me,
Well, I figure that you have a couple hours in this, don't you?
at least, yes.
Okay, well, let me give you 300,
That would be fine.
300, and you add that to that, and I'll give you,
Just with that, I'm talking to people about jobs. I mean,
well, you need to borrow some money and pay this off, okay? You need to pay this off, and is there ongoing obligation? Is that it?
There will be, there's $4,000, she just got a letter after they applied this amount.
She what?
She just got a letter from the IRS, there's a $4,000 balance after this was applied.
So they'll intercept it again.
No, I'm trying to get it taken care of.
Well, I hope you do, but what's the deadline on that?
They just take them every year till this is all paid off. Yes.
Well, those are back taxes for when you were married, right? Well, you're obligated for those. I mean, the only thing you got is an agreement with him that he'll pay them. But that doesn't impact what the IRS will do. They'll continue to get you until he pays it off. Okay, so, you know, I doubt very seriously if you can write any kind of letter to get the IRS to forgive that obligation that y'all had jointly. Well, I don't think they told you right.
If you have any form, you can provide that to me. I
Yeah.
can leave that to your
Well, okay, that's good, but I can't do anything with that to tell them that somebody told you that somebody did this, that doesn't get it, you know? So you have that money paid, the attorney's fees and the reimbursement for that. I won't do anything about the rest of the money that's owed. I'll give you a chance to look about that. But you have it paid in full by July 14th, or appear here with your toothbrush. Okay? Your toothbrush, because I'm gonna put you in jail. What's gonna happen? Okay? I'm gonna put you in jail for 90 days.
That's not very far away. 14, that's just a lot of money.
Well, this is not very much money. You know? Well, you know, you need to come up with the money. You need to borrow the money, you need to do whatever.
Well, this needs to be stopped. I mean, I'm doing everything with my taxes.
I'm telling you, it does need to be stopped, but you know, it's not her fault. It's not her fault that you're not. Well, you're not, why don't you pay the liability off? If you pay the liability off to them and then try to get a refund, y'all wouldn't be going through this, and you wouldn't be going through losing the money to her attorney all the time. So that's just the way it is. Okay? Thank you very much.
Sure, I'll send it forward. If I can be excused, I need to go to Mr. Song.
That'll be true. That'll be fine. Sheila Turner, conservator for Corey versus Jeffrey Cornett. Hello.
Jared Key on behalf of the defendants. That's my motion to approve settlement for a disabled person.
What kind of settlement is it?
It's a personal injury settlement. You are, man, real quick.
What do we got? Just tell me what you got.
I have the order that was submitted said approval for minor settlement. It's not a minor settlement. It's a
Okay,
disabled
right
person,
here.
so I want to substitute the disabled person. It's just a change in the heading, Your Honor. There's Caleb. He just falls.
Okay, give me a background on this.
So, Your Honor, this was a personal injury, car accident case that occurred with Miss Turner and her disabled son, and we reached a settlement with both Miss Turner and the son regarding the claims made. Under the statute, if it's more than $10,000 settlement, we have to have court approval. They've already had a mother set up as the guardian in district court, so just to make sure I cross all the T's and dot the I's.
Who do you represent?
I'm sorry, Your Honor.
Who do you represent?
I represent all the defendants, Jeffrey Corn and J&H Farms.
Yeah, and their insurance company?
The insurance company was not named, Your Honor.
What kind of settlement did you make?
As far as the amount,
Yeah,
can we do that in camera with confidential settlement, Your Honor?
you just write it down, hand it to me, and I'll tear it up. This is your client?
Yes, Judge, I'm stepping in for Kelly Lester on this one.
And so she was represented and the young man were both represented in these negotiations, and you're satisfied, ma'am, with the settlement?
Yes.
And Your Honor, I apologize. I want to make sure I get the exact cent number right for your comments.
You can give me a ballpark figure,
Okay.
write down a ballpark figure.
Thank you, Your Honor. Thank you, Your Honor.
You realize that a portion of this settlement is your son's money, and you have an obligation to file periodic statements with the district court, is that correct?
Yes.
Okay. Sorry. Yes, absolutely. Bailey McFall versus Brett McFall. Hello.
We've got two motions on. One was looking to schedule a hearing, and the other was a motion about closing council for friend of the board. I've got no objection to the one on friend of the board. I would just ask that.
This has been sent to the Domestic Relations Commissioner. What are the issues here?
There shouldn't be any property issues. The only issue will be visitation and goes child support.
Okay, why haven't, I mean, have you all mediated this or anything?
One that had the case for a long time on the other side. We had negotiated, got close a few times.
This is Mr. McFall.
We negotiated, got close a few times, never been able to hammer it out, and then he had recently retained us to fill services.
Where are you from?
Also,
Who you with?
so.
Good luck. Yeah, yeah. I did that myself for several years, you know.
I've got a really good support staff. They're much smarter than I am.
Yeah, yeah. They don't have to be smarter, they just have to be diligent, so, you know. What are the issues with the visitation?
Child support, visitation, and custody.
Well, I mean, child support's usually not an issue, we have forms for that. How many children are involved?
There's 2 kids.
How old are they?
They're 10 and now.
Boys or girls?
Both boys.
We're seeking equal custody, equal time.
Less than that, based on the last couple of years. They've been split for a couple of years.
Yeah, well, we'll just have a hearing on that. We'll go ahead that, and you don't think the commissioner would handle it? Why do you want a friend of the court?
My client had requested a friend of the court just to simply talk with the children and get their perspective on it. And because there's been an issue about whether or not they're spending time with the dad or whether they're spending time with the grandma.
We've got no objection in front of the board. I would just ask that any interview of the children be recorded. That because whenever the front of the board presents their report, we're going to be subject to cross-examination. And I would move for this pursuant to the statute that says any data or any sort of reports, any kind of evidence gathered by that friend of the board is something that is subject to cross-examination. We're entitled to a copy of that pursuant to like 40300. So I just asked for that.
I don't know who we usually use for friend of the court. We got a list. We do for guardian ad litem and for one or more attorneys. You got the list over there. Does either one of your parties have any prior experience with any local lawyers here?
Well, Ms. White was in the case. You were presenting business with any other lawyers?
Ms. White was in the case, was she? So that would eliminate her, and there aren't really anybody else here that's in private practice. Let's just put Ms. Parrish in. Just put Ms. Parrish in. She's local. Got an office over in Burksville. That's okay. Don't worry about the list. Just put Ms. Parrish in. Okay. Okay. And yeah, and tell them that the friend of the court and draw the order like that, and then make sure that she records all interviews for discovery purposes. Okay.
We'll do.
Okay, thank you.
When will this be done?
Well, we'll schedule that.
It'll be done. Well, it's gonna be quicker than that, you know, but if the friend of the court will have to have an opportunity to interview the children and get a report done, and that way she can attend the hearing with Mr. Soam. If it takes more than 30 days or something, get back with me on the 14th of July. If it hadn't progressed any by then, you can come back. I understand you're anxious about it.
Yeah.
I understand you're anxious about it. That's enough. Okay. 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 Thank you very much. Yeah. Owen versus Owen.
Give me a call, I'll kind of go over it.
Owen versus Owen.
Agreed order, Your Honor.
Okay,
Bail, pass it, order, show cause order, be agreed on.
okay, thank you very much.
That's all I have on these.
Sure. Riddle versus Jarvis.
That order's been signed, Your Honor.
Okay. Okay. 76 Falls Vista LLC versus Freddie Robinson. Summary judgment continued from 5/12. Gibson versus Scott. Make sure I come back to this one. Gibson versus Scott. Yes, sir.
Now, this is my motion to reconsider IFP. However, whenever I was reviewing the filings in my truck before coming in, I believe I found what the crew of the issue is. It seems that whenever my client was filling out the IFP, she forgot to designate in there that she actually has a dependent that lives with her. Her daughter is disabled. I forget whether she said mental or physical. So I would assume that the numbers that the court was using was based on a household of one instead of two. And, you know, that would raise.
Who do you represent?
Ms. Gibson.
Where's the other side here?
He has not been served. This was a motion to reconsider her IFP. I was just going to ask, since I caught this error, if I could be given the opportunity to amend it and resubmit it. I think that will change the outcome.
Okay, I'll let you file an amendment. Okay, okay. Okay. Yeah, what, is this the last case? we have?
We got the bailiff out there, Tiffany Bailey. They're on the docket.
That went down to DRC.
The commissioner, they're supposed to go down to the commissioner's office. Yeah. I don't see a copy of the order of summary judgment in here. Enter a summary judgment on this because I gave the respondent 15 days to hire counsel and file response for the motion for summary judgment. It was continued to June 9th. I did not find that we followed that order, so I guess you can call Mr. Connor and tell him to submit a motion for summary, order for summary judgment, okay? Okay, that concludes the business of court. Let's go off the record.